Hearing the appeal, the Queen against Maughan.
Mr. O'Rourke.
May it please the Court, I appear on behalf of the appellant in this matter with my learned friend Mr. Rafferty. Mr. McGee and Ms. Pinkerton appear on behalf of the respondent. As the Court will appreciate, this appeal...
I'm so sorry. Please continue.
The appeal concerns two important issues in relation to the sentencing of those who plead guilty to offences before the court. As a rule, a defendant who pleads guilty will be allowed a reduction in the sentence for the guilty plea, and the earlier the plea, the greater the reduction will be.
Please continue speaking. Thank you.
The greatest reduction will generally be allowed for those who plead at the earliest opportunity, and correspondingly, the discount, which may be reduced if the plea is indicated or entered after that first opportunity. So this is the context in which the first issue in this case arises, namely whether the court may reduce the discount which would otherwise have been allowed if a suspect pre-charge has failed to make admissions in the police interviews. Namely, does the principle of first opportunity, and in particular the statutory interpretation of the relevant provision, permit the court to have regard to the police interviews? The second matter is whether the court may reduce the discount for the guilty plea if it considers that the defendant had no viable defence or was caught red-handed. Now, the facts of this case are set out in the Statement of Facts and Issues which the court has. You'll see that the appellant appeared before Belfast Crown Court on two separate indictments relating to offences committed in July 2015, and then a spate of offences which occurred in July 2016. The court will see the certificate of convictions in this case, which are contained at page 185 in the annex. The appellant received a sentence of 14 years imprisonment. The sentencing remarks of the learned trial judge provide a general factual overview of the offences, and we've set that out in our Statement of Facts and Issues at page 81, which you'll see. And then we set out in some more detail what we consider to be the more serious offences, and we have included those under 5 headings which the court will see. I'm open to the court's direction on it, but it may not be necessary for me to read those into the record, as it were.
There is no need to read in these matters. The court, you can take it, will have read the Statement of Facts and Issues. Will have read the cases of the parties and the judgments below.
Yes, the court will see that the appellant was arrested in the course of one of the offences in July 2016. And he was taken to the police station, and attempts were made to interview him, but you'll see that he wouldn't leave his cell He wouldn't consult with his solicitor, and therefore there was effectively no interview conducted with him. Now, whether that conduct was a product of his intellectual impairment, a conscious decision to resist being interviewed, or potentially due to his state of mind due to drug taking, it's difficult for anyone to say with any precision, either at the time or indeed at this stage. The court will see that he was subsequently assessed by a forensic clinical psychologist who indicated that he suffered from severe learning difficulties. He was then charged in July 2016 with the various matters, and he was then arraigned at Downpatrick Crown Court on the 14th of September 2017. So you will see from the chronology, which is contained at page 90 of the papers, that he, having been arrested on the 26th of July 2016, he made an appearance at the Magistrates' Court. He was then not committed for trial from the Magistrates' Court until the 30th of June 2017. So it took about almost a year to commit him, and then he was brought for arraignment on the 14th of September 2017, when he entered guilty pleas to the various matters, with some other matters on the indictments being left on the books not to be proceeded with. We've set out in some detail in the Statement of Facts and Issues some information about the appellant and his mental impairment that he suffers from, his criminal record, and the report from Dr. Weir, which indicates that he was suffering from a severe learning disability. And then we deal with the judge's sentencing remarks when he came to be sentenced, and in particular we refer the court to paragraph 67 of the sentencing remarks, where the court indicated that it took the view, in line with the decision in Pollock, that the maximum reduction was only due to those who admit their guilt when first confronted with the allegation, and in view of the fact that neither defendant had cooperated with the police on arrest, and given the fact that for certain offences they were either caught red-handed or the evidence against them was overwhelming, he didn't consider that they were entitled to full credit, and having assessed the appropriate starting point as being 18 years, he reduced it to a determinate sentence of 14 years, indicating that he was according an approximate 25% reduction for the pleas. So the basis upon which it appears that the reduction for the plea was reduced, if you like, was on two grounds, namely the failure to admit guilt when first confronted, and secondly, the fact that they were, in the court's assessment, effectively caught red-handed. The court referred to the decision in Pollock, but the principles that the court was relying on, this court will appreciate, stem from two separate decisions of the Northern Ireland Court of Appeal. Firstly, the decision in MacDonald, which deals with the reduction in discount pursuant to Article 33 And then Pollock deals with the principle that if a defendant is caught red-handed, that may reduce the discount. The matter was then appealed to the Northern Ireland Court of Appeal, leave having been granted by Mr. Justice Colton, and it was heard then in September 2018 and October 2018, and the court refused the appeal, affirmed the sentences, and in relation to the two issues which are before this court, those are dealt with at paragraph 90 of the Court of Appeal's judgment, which is at page 178 of this court's papers. And the court held that the stage of the proceedings, which is the term used within Article 33, the stage in the proceedings for the offence which the offender indicated his intention to plead guilty is not limited to court proceedings and includes the police interviews. And in respect of the second matter, the Northern Ireland Court of Appeal took the view that with some amendment, the principle in Pollock was good, and that the discount accorded for a plea of guilty could properly be reduced in circumstances where, on the court's assessment, the offender was caught red-handed or had no viable defence. Now, if I may take the court to the case statement on behalf of the appellant, we set out again the text of the sentencing remarks of the learned trial judge at page 91, paragraph 2 of our submission. And then we say that we set out the basis upon which the court reduced the discount in this case. And then we say that the starting point for consideration of this case is essentially that the discount on a sentence for a plea of guilty in Northern Ireland is generally about 1/3.
And that is a matter of sentencing practice rather than any statutory provision.
Correct. Yes, it's not unlike this jurisdiction in England and Wales. The practice in Northern Ireland is entirely at the discretion of the court. But as you will see from the decision of the Lord Chief Justice, Sir Declan, that in McCone and Hanlon, they observed that the full discount for a plea is generally in or about 1/3, where the offender faces up to his responsibilities at the first opportunity. And that roughly accords with the position in England and Wales under the sentencing guideline provision. It's 1/3 discount. A lot turns upon the timing of the plea and when it's entered. And that's one of the issues that we have to consider. Now, we then turn to issue 1, which is the failure to admit guilt when first confronted. And we set out the passage from the decision of the Northern Ireland Court of Appeal. The Lord Chief Justice Kersey was then in MacDonald at paragraphs 17, 18 and 19. And we stopped at that point. The court referred in paragraph 17 in MacDonald to Article 33(1) of the Criminal Justice Northern Ireland Order 1996 and set the text of that out. And went on to say that if a defendant wishes to avail of the maximum discount in respect of a particular offence on account of his guilty plea, he should be in a position to demonstrate he pleaded guilty in respect of the offence at the earliest opportunity. It will not excuse a failure to plead guilty to a particular offence if the reason for delay in making the plea was that the defendant was not prepared to plead guilty to a different charge that was subsequently withdrawn or not proceeded with. And then to benefit from the maximum discount on the penalty appropriate to any specific charge, a defendant must have admitted his guilt of that charge at the earliest opportunity. In this regard, the attitude of the offender during interview is relevant. The greatest discount is reserved for those cases where a defendant admits his guilt at the outset. Now, we go on to observe, in respect of that passage, that that judgment has been subsequently interpreted, we say, as indicating that if admissions are not made in interview, there may be a reduction in the notional discount that is to be attributed. In fact, we say that the judgment doesn't necessarily say that because it's our submission, consistent with the sentencing guidelines in England and Wales, that if admissions are made in interview, it may it is relevant, and it may reduce the sentence even further, whether by reason of personal mitigation or whatever. And therefore, it is possible to read the passage in MacDonald as being entirely consistent with that principle, that the reduction for the plea is one matter, but there may be some additional reduction if admissions are made in interview. We say that subsequent decisions in the Crown Court in Northern Ireland and the Court of Appeal have read that passage as indicating that the reduction for the plea of guilty may be reduced where there aren't admissions in interview.
But isn't that what happened in MacDonald?
That is what happened, and therefore it's not surprising, we say, that courts have gone on to interpret it in that way. But I think a careful reading of MacDonald may not...
Well, you missed out the rest of paragraph 19, which makes it clear on the facts how it was treated.
On the facts of that case, neither defendant had made admissions in interview and therefore weren't entitled to full credit. The question really is that the full credit under Article 33, or is that the full credit that one could get if admissions were made at an early stage?
I mean, is the problem the emphasis on admitting guilt of that charge at the earliest opportunity? At that point, there is no charge.
Correct, my lord. I'm grateful. That is correct. There is no charge of that, and one of the...
I mean, forgive me, just to pursue that thought a little further. If one is talking about the stage in the proceedings for the offence at which the offender indicated his intention to plead guilty, can that operate unless a charge has first been made?
Correct, because what would he be admitting to precisely unless the charge is specified? In many instances, it may be readily apparent what the nature of the allegation is, but your argument is correct. If the charge is not preferred, there can be no indication of admission to that charge.
Yes, sorry, Sir Declan.
Following that up, if admissions are made about the circumstances of the offence, and the accused then pleads guilty at arraignment without any further indication one way or the other, is the accused entitled to the statutory discount under Article 33 by virtue of what the accused has said in interview before the charge?
In our submission, no.
Right.
Article 33 deals with, if not the court proceedings, at least from the point of charge, we say that this court should give some guidance as to when the first opportunity is in Northern Ireland to admit, and we say that ordinarily should be arraignment for reasons that I'll come to. But an accused before a court could legitimately ask for credit for the admissions made in interview by way of personal mitigation.
But would not fall within the statute on your submission?
Yes, because there are no proceedings at that stage, we say, in place.
Can't stage of the proceedings include pre-proceedings?
We say not, because stage of the proceedings must mean it's a stage in the proceedings, not a pre-proceeding stage in our submission.
And just while I'm there, in terms of the meaning of proceedings, does the definition which applies in Article 47.10 of the 1996 order have any relevance to the interpretation in Article 33?
I need to come back to.
Yeah, Article 47 is the provision that deals with jury tampering or matters of that kind, and it provides a definition of when those proceedings have to be instituted. Yes. A time limit within which they have to be instituted.
As with all statutory interpretation, the context of the provision is vital to the interpretation, we say. And that is why when one looks at the three provisions which are in existence here in Northern Ireland, in England and Wales and in Scotland, it's quite clear that the purpose of the provisions are identical, namely to achieve early pleas from those who want to plead guilty for a public benefit. And we say that the provisions in England and Wales make it clear that the proceedings relate to court proceedings, not to some pre-charge proceeding. And if we're right about that, and the statutory intention is the same, then we say it follows that the correct interpretation of the Article 33 is that proceedings relate to court proceedings.
Well, isn't that a non sequitur? I mean, there may be exactly the same purpose of gaining the benefits of an early plea, but as to how you go about gaining that benefit, that can vary from jurisdiction to jurisdiction.
No, I entirely agree with that proposition, but on the simple interpretation of the statutory provision, we say that the three provisions should be interpreted as meaning the same. Now, when the earliest opportunity will arise in a particular jurisdiction may vary depending upon the circumstances, but the meaning of proceedings is the same, we say, in the three provisions, meaning they are court proceedings, and that's the trigger for the discount. At what stage in the court proceedings did the accused make the admission?
Mr. O'Rourke, I have difficulty at the moment in seeing why the different legislation in the different jurisdictions should be read in a manner which is consistent, and why the word proceedings should bear the same meaning in each different context.
Well, we say that the three provisions came in very close to each other, we say, for precisely the same purpose, to achieve early pleas, following on from the Commission report that we refer to. If proceedings in the Northern Ireland provision includes pre-charge matters such as police interviews, then the words that of in that court or another court, which are used in the England and Wales provision, we say is unnecessary, because one could have left those words out, simply used the same language as Scotland and Northern Ireland, and all proceedings right back to arrest and questioning would have been included. And we say that the provisions in England and Wales clearly intended to cover the particular situation in England and Wales, whereby one can indicate a plea at an earlier court, in the magistrate's court, And the only purpose of inclusion of the words in the English provision was to indicate to the sentencing court that it could take account of that earlier proceeding. So we respectfully say that those words in the provisions in England and Wales would have been entirely unnecessary if proceedings could be taken right back to interview. But I'll come back, if I may, to that when we look at the statutory analysis just a little later in our submission. We say that whether the court can in fact take into account the interview stage essentially turns upon what is meant by proceedings in Article 33. And then when you examine the statutory, the history of the statutes in relation to this, it starts, we say, with the Royal Commission report, which was followed very soon thereafter with the provisions in England and Wales. I should just, in passing, observe, as we do in the submission, that in the Royal Commission report, the report indicates the most generous discount should be available to a defendant who indicates a guilty plea in response to the service of the case disclosed by the prosecution. Now, I appreciate that subsequent cases have elaborated on the current position as to when a defendant is expected to plead guilty, but it seems to us that the Royal Commission at least was indicating that the defence would know something about the case or the charge that is being made against.
Well, that was the point Lord Burrows, I think, was making about you need to know something about the charge before you indicate a guilty plea. It's not simply a matter of saying, yes, I was there, yes, I did it. What is it you're being charged with, and what are you pleading to?
One of the concerns that it seems to us that arises is that the cases upon which the respondent relies in England and Wales emphasise that a defendant may know that he's guilty of a particular offence and therefore can be expected to admit the offence. And indeed that is often true, but he's also entitled to legal advice in relation to his position, not necessarily to advice in relation to potentially, say, for example, seeking to exclude evidence or to delay the plea to a stage to see if someone turns up. But a defendant may say, I would like legal advice on my position as of now. And it's difficult to see how a lawyer, without having the evidence, at least in some preliminary form, could properly advise his client in relation to his legal position.
But surely, Mr. O'Rourke, I mean, there's a well-trod line of flexibility and discretion in relation to sentencing policy to recognise those cases where there's some reason why, some acceptable from a sentencing policy point of view, reason why somebody might have delayed facing up to their responsibilities.
Yes, but even when the exception may not apply, we say that as a basic right, an accused must be entitled to consult his lawyer about his position. Even
though he doesn't need the lawyer to alert him to the fact that he has behaved criminally?
Yes, he may well be admitting all of the material ingredients to the offence, and the lawyer's advice might well be that the case is sustained against him. But he nonetheless must, as a basic right, be entitled to consult his lawyer even where he's admitting and acknowledging his own guilt. And a lawyer in coming into the case must be entitled to know something about the case in order to discharge his obligation to his client. I mean, he could well advise his client about the regime that he will get the greatest credit for the early plea or whatever. Those are generic issues that he could advise anyone without knowing anything about the particular allegations against them. But to advise him in relation to the particular case, it's our submission that the lawyer would need to know something about the evidence that he's been accused of. And therefore, one has to be careful in our submission of immediately adopting the position that it becomes a moral issue for a defendant to admit guilt rather than illegal. It's partly moral on his part, but also there's an element of if he's entitled to legal advice, there must be a right of the lawyer to know the nature of the evidence.
And you say that under the English system, as I understand it, you have a clear-cut distinction between the guilty plea and the admissions and cooperation with the police, which will lead to a greater than 1/3 discount.
Yes, under the sentencing guidelines, if there were admissions made in the interview, that could be taken into account in determining the headline sentence. As
it goes to mitigation.
Mitigation.
Yeah.
Therefore, instead of having, in this case, a starting point of 18 years, it might have been reduced to some extent as a headline, and then the plea is the
But it's going to be 1/3 plus the mitigation.
Yes. Now,
well, the third itself is a matter of judicial practice. There's no statutory requirement here at all.
No, in Northern Ireland, it's a matter.
But there is in England and Wales.
There is in England and Wales, yes.
Yes.
But I mean, Scotland is much more, with which I'm more familiar,
yes.
Is more aligned to the Northern Irish situation.
Yes, the guidelines don't apply in Scotland. It's a matter for the discretion.
And also our legislative provision is much closer to the one we're looking at today.
Yes. But whenever the point is made by the court in Deploy that, and we respectfully adopt it, that the purpose of these provisions is to incentivise defendants who are guilty to admit it at the earliest opportunity, for the variety of reasons that are set out in the cases and in the sentencing guidelines. But in order to achieve that, defendants coming before the court must be able to assess the discount, at least in broad terms, as to what they are likely to get, what discount they're likely to get. Because if they can't make an assessment of that or can't be advised in relation to that, the purpose of incentivising pleas, we say, is likely to be lost. And one of the concerns that we have in relation to the Scottish decision in Gemmell, which the court took the view that there is no presumption of a discount, that really to get a discount, one has to look at what the actual benefit in the case was, and assess the discount according to what that actual benefit was. I think that creates a number of difficulties. Firstly, a defendant may be expected to plead before that assessment can be made by the court. And therefore, it would be very difficult for an accused person to know what discount they're likely to get without that assessment being made. And secondly, there is a real danger, we say, that if the sentencing court in every case has to measure the benefit in the particular case, many of the advantages of the discount will be lost. For example, the court might have to conduct some form of inquiry into for example, the willingness of the complainants to come forward in a case. So, for example, one could have a situation whereby the prosecution may be saying that a complainant was quite willing to come forward, and that may be disputed, and an accused might be saying, well, our information is that she was very reluctant, therefore the benefit should be greater. And we respectfully submit that, consistent with Cayley, the system really only operates properly if it is a broad brush approach without a detailed analysis of the benefit in every case. That there is, if you like, a general rule, subject, of course, to what might be considered to be particular circumstances in any individual case, but there is a general rule as to what the benefit will be in a particular case.
But again, that sort of issue is a matter of judicial practice, isn't
Yes.
it, rather than law? And this court's primary purpose is determining points of law of general public importance. I'm not sure it is for this court, which will not have the same experience as judges in Northern Ireland, to be laying down judicial practices in the province.
No, I'm not in any way disagreeing with that, my Lord. It's just that you'll appreciate that the respondent in this case argues that you can't compare the respective jurisdictions, and our submission is that whatever the discount may be for a plea at the earliest opportunity, there should be some consensus about what that should be as a general rule. We've set out what we say is the meaning of proceedings at page 98 of the bundles. And we set out what we say
just in relation to the meaning of proceedings, when do you say proceedings are instituted, criminal proceedings instituted?
not before charge.
No, but that's not the question I asked. When do you say they are instituted? Is it charge or not?
Well, this case only concerns...
No, but just to get the answer to the question first, when are proceedings instituted in charge cases?
Well, we would accept that at the point of charge, it is at least arguable that there's a proceeding now in place.
Well, do you accept the argument?
Yes, from charge.
Do you accept the argument that from charge the proceedings are instituted?
Yes, because at that stage the matter has to then go to a court.
Now, in relation to summons cases, can you just tell me when do you say that criminal proceedings are instituted in summons cases?
Well, this is why we respectfully invite the court to take a view that proceedings should commence later in Northern Ireland to accommodate the different... Otherwise, one arrives at a situation where proceedings may be different in different circumstances.
But all I want to do is get just your answer to the question. In summons cases, when do you say proceedings are instituted?
A summons to appear for committal proceedings.
So it's the issue of the summons that's the commencement of the proceedings. I just want to get the answer, Mr. O'Rourke.
Well, I'm not entirely clear about the question with respect.
Well, the question is, when are criminal proceedings instituted in summons cases?
Does yours mean a summons to attend for committal?
I'm talking about an indictable case where person's been interviewed and has been told that the matter is going to be reported to the PPS.
Yes.
Subsequently, a summons is issued, which is usually a summons to appear for a committal hearing. All I want to know is when you say criminal proceedings in relation to those matters commence.
It couldn't commence before the issue of the summons. So the summons is the earliest time a proceeding could be in place in those cases.
Right. So you accept that it's initiated by the summons is your case?
Yes, because that's the formal notice to attend a court for the proceedings.
Yes, that must be the logic of your position. If you're saying it's court proceedings until you either are charged and will be appearing in court, I think, very, very promptly thereafter, or in the summons proceedings, you are summoned to the committal hearing. You say there are no court proceedings to which Article 33 can bite on.
Yes, I accept that once a charge is initiated or a summons is issued, there is a proceeding in place at that point. That's not the same necessarily as the first opportunity to indicate guilt, which might be at a later stage.
Because that's the first time one would be in court as a result of those proceedings.
Yes, I mean, in a situation, for example, if someone is arrested and questioned about a matter and then are released without charge with an indication that they're going to be reported to the authority with a view to prosecution, there can't be any proceeding in place. There may or may not be a proceeding at that stage. The matter may never come to anything. They may receive a letter indicating that there's going to be no prosecution.
I think what I'm driving at is one's not suggesting there can be any indication of plea unless you're in front of a court.
Yes. Yes, that's our submission. You will note in Cayley the court mentions a formal indication of guilt, and one of the concerns that we have is that an admission in interview isn't a formal admission of guilt for court purposes.
Well, I mean, I think I, for one, would find it helpful if I know exactly when you say Article 33 bites. You're saying that there may be proceedings, either in charge cases at the point of charge or in summons cases, in indictable cases, at the issue of the summons. But you're qualifying that by saying, well, there isn't an opportunity to plead at that stage. You're wanting to push the starting point of Article 33 a bit later. Am I right about that?
Yes, there are two issues in our submission. The first is whether there is in existence a proceeding, because we say that Article 33 doesn't operate until there is a proceeding in place.
Yes, and we have your position on that.
And that may vary depending on the nature of the proceeding, whether it's charge or summons.
And the next question is, what is the stage of proceedings that Article 33 bites on? And what's your position on that?
Yes. In our submission, it's capable of varying from case to case, but for the purposes of consistency, it's important to have some general indication as to when the earliest opportunity to indicate guilt will be.
Is that why you say that it should run from arraignment?
Yes, because that is the first, in Northern Ireland, that's the first opportunity that an accused has to formally indicate his position.
It might be the first opportunity before a court, but once the proceedings are in course, following the charge or the summons, why is it not possible to indicate an intention to plead guilty without actually appearing before a court?
In, for example, the magistrate's court. Well, in Scotland,
Well, not necessarily before a court at all. An indication could be given in correspondence.
That's possible. It doesn't happen in Northern Ireland that the correspondence presumably sent to the Director of Public Prosecutions. That is possible that that could be done akin to the formal situation, the statutory provision in Scotland, whereby there is provision to provide a letter admitting guilt. But we say that it would have to be done on a formal basis rather than an ad hoc, impromptu basis from case to case. It's obviously open to the legislator to make a provision for that to be done as they have in Scotland. And
Article 33 doesn't require a plea of guilty, it requires an indication of an intention.
Yes, and in Scotland there is a particular statutory provision which facilitates that, whereby the letter is sent to the Crown agent, and that is, providing it's adhered to then at arraignment, that entitles the defendant to the discount. It would require, we say, some formal basis, and one of the difficulties that would arise in those situations is what would be the position with an unrepresented defendant who may or may not be familiar with doing that. Would an unrepresented defendant or a defendant who was unrepresented at an early stage lose his discount because he, unqualified as he may be, didn't send a letter to the Crown indicating he intended to plead guilty?
But surely that's something that would be dealt with by the court as part of its normal approach to the individual circumstances of the case, Mr. O'Rourke. I mean, it's certainly not this case, because you had a solicitor there seeking to engage with your client.
Yes, and it may well be that we say that if there was a formal process where that could be done, in a case like this, it's very likely that it would have been taken up by the accused. He would have indicated. This is a case where the defendant indicated he was pleading guilty at arraignment, at what we respectfully say was the first opportunity he had of doing that. Now, I take the court's point that it is possible that solicitors on behalf of clients could write letters to the prosecution indicating my client intends to plead guilty, but it would be an ad hoc, informal, unregulated system which isn't in operation. And if a simple provision, statutory provision to provide for that would probably facilitate the expeditious pleas that are in the public interest.
So certainly in Northern Ireland, in light of the cases that you've referred to, the importance of ensuring that you indicate your intention to plead guilty at the earliest opportunity could not possibly have been lost on a represented person.
Yes, but I think the difficulty is that the perception, at least of practitioners and indeed the court, that the first opportunity is the arraignment. The court will see, for example, that in the leave judgment of Mr. Justice Colton, he indicates that arraignment is the first opportunity to indicate guilt. Now, that's the perception of the senior criminal judge in Northern Ireland, and indeed is the perception, we say, of practitioners.
But at the arraignment, you would have the opportunity not to indicate an intention, you'd have an opportunity to plead. Is that not right?
They may be the same. I mean, the entering a plea is also an indication, but an indication isn't necessarily entering, so there's a slight distinction. But it doesn't follow that it's at an earlier stage prior to arraignment. For example, arraignments are often adjourned for one reason or another for example, in a multi-defendant case, some of the defendants may seek an adjournment of the arraignment and the whole arraignment is adjourned, but there may well be an indication from one or more of the defendants that they intend to plead guilty, but they aren't formally put on their arraignment at that stage until the court has dealt with the other outstanding matters. And so that often happens. So it isn't necessarily, an indication of a plea doesn't necessarily mean some stage prior to the Crown Court. It can occur at the Crown Court. And indeed, in the committal proceedings, as the court will...
I can see if you're in the Crown Court and the arraignment is continued, you can indicate an intention to plead. But if that is right and the arraignment doesn't take place, if your interpretation of the article is that that would be a valid indication of an intention to plead guilty in proceedings, then why do you need arraignment?
No, the arraignment's a formal...
it's simply the formal opportunity to plead guilty.
Yes, but we say that it often happens in the type of situation that I've described to the court, whereby the arraignment isn't facilitated at the first opportunity, or first appearance. It generally, arraignment occurs on the first appearance, and the accused is arraigned and enters his plea guilty or not guilty. But very often, the arraignment is adjourned, not necessarily because a particular defendant seeks an adjournment, but because maybe some other defendants are raising issues.
Well, in that circumstance, how do you say the provision operates? Are you saying we ignore, for the purposes of Article 33, any indication made at the hearing when the arraignment is postponed? Or are you saying that falls within Article 33?
Oh, that falls within Article 33. The proceedings are underway. That's an indication of the intention to plead guilty.
Yes.
The actual entry of the plea may occur at some later stage, yes, convenient to the court. So that's clearly within Article 33.
I see. Thank you.
If the arraignment is so long after the charge, as it was in this case, it was about 15 months, I think, that would mean that many of the benefits which are intended to arise from discount for an early plea would not actually be achieved, would they?
I entirely agree, my lord, but that doesn't, with respect, isn't cured by imposing the obligation on an accused to make admissions during an interview. The remedy for that is to devise and introduce a system whereby those matters are expedited, or there is a facility, formal facility, to enter or indicate a plea at an earlier stage. The problem...
But it might indicate that Article 33 was intended to operate from an earlier stage than arraignment.
Well, I respectfully submit that that's not a correct interpretation of Article 33 if one takes into account the provisions in England and Wales, for the reasons that we set out in our argument, and I won't go back over those again unless Your Lordship wishes me to do that. But
I just want to be clear, Mr. O'Rourke. So you accept that proceedings start in a charge case at the time of charge, is that right?
Yes.
But you say, because there's no formal mechanism of indicating guilt, Article 33 can't in fact operate prior to arraignment. Is that it?
No. Article 33 could operate prior to arraignment if there was an indication given. The problem in Northern Ireland is that there is no formal method of doing that, of indicating guilt. Our argument is that Article 33 doesn't operate prior to charge, i.e. during the investigative interview stage, which is this case.
But you accept it operates from charge, do you?
Yes. The proceedings would commence from charge.
Right.
And then the next question is, what is the earliest opportunity in those proceedings that an accused can indicate his guilt.
You say that can't be at the charge stage, it has to be at the formal arraignment stage, is it?
Well, he could admit it in guilt. I mean, he's asked for a reply after charge, and he could admit that. But one of the difficulties would be that a charge generally arises immediately following the interview of an accused. The lawyers who are engaged may or may not know very much about the case, other than which they gleaned from the questions that are asked in the interview. They won't have received any material.
Well, that will vary from case to case, won't it? But you're looking for a general rule that everybody can understand and apply, as I understand.
Yes, for consistency and the proper operation of the encouragement to plead guilty, we say that arraignment should really be taken as the first opportunity in Northern Ireland to admit guilt, until a more formal pre-arraignment process is enacted to facilitate that.
But that's not because proceedings don't start till arraignment. It's because you say there's no satisfactory formal process indicating intention to plead.
Yes.
Would one need an enactment, or would it be sufficient for a senior criminal court to lay down a practice? I'm not quite sure why. If you're right about proceedings, i.e. post-charge, post-summons, then would it not be sufficient for a court to say that a perfectly acceptable means of indicating an intention to plead guilty is a letter to a particular authority?
Providing it's done on some formal, not necessarily a statutory basis, but at least on some clear basis that is understood by everyone, not a case-by-case ad hoc basis.
Yes, you're looking for clarity by the articulation of a general rule.
Because let's take this case as an example. Let's say the appellant in this case had made admissions during his interviews. None of the benefits that would flow from a plea would have occurred. The prosecution would still have prepared the committal papers. They would have had to. They would have still have prepared the committal papers. The committal would still have occurred, and he would still have been produced at arraignment to formally indicate his plea, even if he had made admissions in interview.
Well, there would be relief for the victims, wouldn't there?
Well,
and there'd be relief for the witnesses.
There may or may not, my lord. It may depend. Certainly, police could give an indication to victims that he has made admissions, but admissions in interview are no guarantee that a plea of guilty will be entered in the trial. As the court will appreciate, very often the admissions are sought to be challenged, and indeed in this case, given the intellectual impairment of the defendant, which we now know about, that if this had been a contested case, that would have been, if he had made admissions, would have been a realistic contested matter in the trial. So, whilst it may assuage the victims to some extent, until a formal acknowledgement of guilt is entered to the court, we respectfully say any admissions by an accused is not binding upon him. It may be difficult to challenge in the trial, but once a formal admission is entered to the court, then of course then an accused can't set that aside, save for very exceptional circumstances.
But the legislation itself in Article 33 doesn't seem to contemplate an irrevocable step so much as an indication of an intention.
Yes. Yes, but it contemplates that a plea has been entered. In other words, a plea has been entered by an accused, and then the court, in determining the discount, has regard to when there was an indication of that plea. But it must follow with the plea itself to enable the discount.
Yes, of course. That goes without saying.
Yes, but my submission to your Lordship is that an indication of guilt in interview is no guarantee that there will be a plea entered at arraignment. So it does require, in our submission, some formal indication to a court. And in Scotland, under the provisions of Section 76, there is a statutory formality whereby a letter is sent to the Crown Agent, and that is the indication. As I say, the difficulty that this appellant faced is that had he made admissions in interview, it wouldn't have altered the course of the case one iota. The court will note the observations of the Court of Appeal in England and Wales in Keeley. That court was considering the 2007 sentencing guidelines provisions, which had equivocated upon the first opportunity to make admissions and postulated the possibility that may be at the interview stage. And in Keeley, we've set it out at paragraph 12 at page 844 of the papers. You'll see that the prosecution in Keeley didn't seek to make a case that the first reasonable opportunity was at the interview stage, and the court said, we agree that would require a significant adjustment of general practice, and we respectfully agree with that observation by the court in Keeley.
What do you say would be required in order to make that effective?
You may have to change the caution, as the court indeed in Keeley said. It may have implications for the caution, but it certainly would have implications for the disclosure or information which a solicitor attending at the interview would be entitled to know. Your Lordship will appreciate that, particularly in serious cases, very experienced detectives conduct what are called structured interviews. They very carefully, they don't disclose what the nature of the evidence against the suspect is. They engage the suspect with, insofar as they can, with an account. The accused may give an account or may not, and then slowly the evidence may emerge which either contradicts that account so it's difficult in our submission if some adverse sentencing implication is going to follow from those interviews. We would respectfully submit that solicitors attending should be entitled to know more about the case before their client is committed to answers in that type of structured interview situation.
Well, under the PACE guidelines, they are required to have sufficient information to understand the nature of the case that is being investigated. Isn't that correct?
Yes, that can vary from case to case. It can simply be the nature of the offence, a broad, very, very, very vague account of what the allegations are. It generally will not contain the detail, for example, of fingerprints and DNA and or sightings by witnesses, etc., that police will come to in due course as the interview develops. So, if the interviews are to be regarded as the first opportunity under Article 33, we respectfully adopt what the Court of Appeal in England and Wales said in Keeley, that it would require some significant adjustment to the
presumably
process.
the general practice in Northern Ireland has been guided by MacDonald, and that since that case, solicitors have been advising to get maximum credit, you have to admit guilt at interview. Is that not right?
Yes, but the solicitors can do no more than just say that's the principle. You have to admit. But my respectful submission to the court is to have an active participation in that process. Solicitors would need more information about the nature of the allegations, etc., before the accused is interviewed. And it probably, in our submission, would require some adjustment to the caution, as is suggested.
But even on your approach in relation to Article 33, you would still, I take it, accept, as in Cayley, that admission at police interview, which is then later adhered to in an indication of an intention to plead guilty, and then the pleading guilty would be additional mitigation.
Yes.
Yes. So whether you alter the top line before you apply the discount, or whether you apply the discount, I mean, the accused person has exactly the same interest in knowing how his behaviour at interview is going to affect the bottom line, the ultimate sentence that is achieved.
Yes, but except if you're comparing two identical cases where one has made admissions in interview and one hasn't, then the outcome would be different.
You're accepting the outcome quite properly would be different.
The outcome would be different because one would get additional mitigation for his admissions in interview.
Reducing the top line before the discount's applied.
And our submission would be is that if you take that admissions in interview into the Article 33 equation, then the outcomes are different for the respective cases.
But the outcome in Northern Ireland is that you'll probably find that the discount will be 25% if you choose to wait until arraignment.
It would be a matter for the sentencing courts as to whether they adhere to hand in and indicate that it's generally a third, or whether the court should say it should be something less.
Yes.
It's a matter for the sentencing courts.
And that's what the sentencing judge did in this case. He took the view that this was a 25% case.
Yes, but what he did in this case was he indicated that the discount would have been higher had they made admissions in interview under Article 33, and we say that was not permissible.
But if he'd said that the discount would have been higher because there'd been admissions in interview, that would have been fine.
Well, what in fact Cayley invites is that if admissions were made during interview, the headline sentence would have been adjusted.
There are two ways sometimes of doing this. You can either affect the headline sentence, which is probably the better way to do it, and then apply the discount, or you can wrap it up, as it were, in the discount. But, I mean, in effect, if he'd said it's 25%, it would have been a third. If he'd pleaded at interview, there would have been no criticism of that.
Accused presumably will be told that admissions in interview will get credit. That's clear from the authorities. What isn't clear in our submission is if an accused either doesn't make admissions or disputes the matter in interview, how that affects the Article 33 adjustment. If, for example, the court takes the view that at arraignment it's a third or 25%, as the case may be. A lawyer advising an accused would be able to tell him in advance, if you plead guilty at arraignment, you will likely to achieve a 25% reduction. In the current situation, it's our submission that the lawyer would have to advise his client that notionally it's 25%, but you may lose some more because you didn't make admissions in interview. So it's whether it comes in within the Article 33 discount or some additional discount is important in terms of advising defendants when they are being asked, are they pleading guilty or not guilty? And for the reasons set out in Deploy, the public policy of transparency and certainty is important to incentivise pleas.
Can I just ask you this, Mr. O'Rourke, which is troubling me on your submissions? As I understand it, in Northern Ireland, you're saying that, or it's your submission, that the first available opportunity is the arraignment.
Yes.
Now, if that's the case, there would be no point in this, as it applies to Northern Ireland, in this legislation, having the words indicated his intention to plead guilty, right, because it might as well say the stage in the proceedings for the offence at which the offender pleaded guilty.
Same for the situation that I've canvassed with the court.
Yes, but you're not saying that was the first reasonable opportunity. In answer to the questions that have been put, you're saying, oh, well, there might have been an earlier opportunity, but it isn't one that would be regarded as the first reasonable opportunity. I mean, you're talking about the adjourned scenario.
Yes, if the arraignment. So after a committal, the next appearance is generally in the Crown Court. That is the first opportunity to indicate the plea of guilty. It may or may not be the arraignment date. The arraignment may occur at a later stage. So it doesn't follow in our respectful submission that the words are unnecessary. So one can have a situation where an indication can be given at the first appearance in the Crown Court, but the arraignment occurs at some later stage. The difficulty that we submit exists is that how does one indicate prior to arraignment? The Magistrates' Court doesn't record an indication of a plea. The accused is not asked how he pleads at the Magistrates' Court at committal.
Well, that's why I thought your submission was it is on arraignment.
Yes. Well.
And then my point becomes, no, well, on that, there's no point using the words indicated his intention.
Well, sorry, it's the first appearance in the Crown Court is the earliest opportunity to indicate.
I mean, Mr. O'Rourke, when somebody is brought forward on a charge to the Magistrates' Court, that person is represented almost invariably. And the next question that comes up is the question of bail, if he's held in detention. I mean, quite regularly, or not irregularly, it may be indicated that the accused has made admissions with a view to indicating that there will be no interference with witnesses as a result of that. Is that not an example of an early indication of an intention to plead guilty?
Well, it's difficult to take a notional case and say that was an indication of intention to plead guilty.
Just taking that case, is that not an indication, an early indication of an intention to plead guilty? I mean, I'm just asking.
Well,
the answer is yes or no, and then the explanation.
I don't think it could be taken as a formal indication of intention to plead guilty, because that it may change there may be no further mention of that when one goes to the Crown Court.
Yeah.
But the difficulty that...
But it would be recorded, of course, by the court, because it would be a factor to be taken into account in whether or not to grant bail.
It may or may not be recorded by the court. In England and Wales, the answer to the questions asked at the Magistrates' Court are then provided to the Crown Court, so there is a clear record of what the answer was. The difficulty arises as multifaceted, that very often an accused may admit facts. There may be a narrative admission, in other words, about certain facts, but not necessarily admission to the particular offence. But secondly, in the summons type situation, how would that operate, where an accused has been released after interview and then receives a letter or summons to attend the court for committal hearing? The first appearance they have is at the committal.
Yes.
And
the question is whether or not there is a prima facie case to justify committal to the court. And certainly at that stage, it could be the representative could say, has the opportunity to say that the offences are admitted.
Yes, but it would make no difference at that stage, firstly, because the next stage is within a matter of weeks he's in the Crown Court in any event.
It would make a difference in the sense that the witnesses would not need to be organised, because at that stage the witnesses would not have been told that they had to attend on such a date. They could be told that they are highly unlikely to be needed, and the victims could be told that there would be no question in appropriate cases of them having to make their way to court other than to see the plea.
Well, the witnesses are not likely to be needed for quite some time in any event if a trial was necessary, because it's unlikely a trial would take place within the short term after arraignment. But in any event, it's our submission that while some assurances might be given to witnesses about the fact that admissions were likely to be made at arraignment, the prosecution couldn't, in our respective submission, couldn't proceed on the basis that an informal indication given unsolicited at the Magistrates' Court would be adhered to. The prosecution would have to set its case up for arraignment irrespective of those indications in our submission. So the utilitarian benefit of an indication in the absence of a formal method of doing it couldn't be achieved in Northern Ireland in our submission.
But presumably there have been many cases post-MacDonald where credit has been given on the basis of an indication of plea prior to arraignment. I mean, there must be many cases where they've got a third, because that's exactly what they did. Is that not right?
Yes.
So there was no difficulty in those cases?
Those are in where admissions are made in interview. We say that's mitigation that can be accorded to an.
But in practice, it's been when that's how they get a third. Is that not right in Northern Ireland? I'm not entirely sure that that's correct. I think that there have been many instances where a plea on arraignment has attracted a discount of a third. In other words, there isn't any universal practice in Northern Ireland that certainly I'm aware of reducing the notional third to a lesser amount at arraignment. Well, I thought that's what MacDonald says, and that represents the practice in Northern Ireland.
No, well, I think that MacDonald is indicating, as I understand it, that if admissions are not made in interview, it may reduce the discount.
Exactly.
Yes, but
it's not suggested that the approach of the judge in this case is an outlier, is it?
No, the complaint that we have in this case is that the learned trial judge in allowing the discount under Article 33 reduced the discount for the failure to make admissions in interview.
And indicated that he was doing so because of the binding authorities from the Court of Appeal as to how he should approach it.
Yes, and we
And any other judge is likely to have done the same.
The court could have taken that the view that the arraignment was the earliest opportunity, and that the full discount, whatever that be, whether it be a third or 25%, was attributable. Yeah. What we complain of in this case is that the discount at the first opportunity was reduced because of the failure to make admissions in interview. And we say that's offensive to the proper interpretation of Article 33. The Court of Appeal in this case took into account the different practices in England and Wales of interviews being where an accused is represented or assisted by an accredited person under the police station representative accreditation scheme. And we respectfully submit that that shouldn't be a material difference, for the simple reason that in many instances suspects will be represented by a qualified solicitor in England and Wales. And the logic of the decision of the Court of Appeal is that in those cases, the failure to make admissions in interview would be relevant, whereas if an unqualified solicitor or an unqualified person is appearing with the suspect, they wouldn't be. The respondents in this case pose an example of a person in Basildon who is charged with an offence and is promptly brought before the court and enters a plea, as compared with a situation in Northern Ireland where they say that the person in Northern Ireland who's then not brought before the Crown Court for a year later asks for the same discount. But in that scenario, we ask respectfully, if in that situation neither accused made admissions during interview, so the man in Basildon didn't make admissions in interview, the person in Northern Ireland didn't make admissions in interview, why should the person in Northern Ireland receive a less of a discount, the notional discount, than the person in Basildon, due to the processes that operate in Northern Ireland, whereby he's not brought to court to enter his plea until a year later? It's not the fault of the accused that gives rise to the difficulty. It's the fault of the system, whereby he's not produced and asked for his plea for a year later. And we respectfully submit that illustrates the unfairness that would arise if a person in Northern Ireland was, if you like, prejudiced in the discount that he might receive for failure to make admissions in interview, as compared with the situation in England and Wales. We say that there are various practical reasons why the court should consider that the earliest opportunity to enter a plea in Northern Ireland is at least first appearance in the Crown Court. Some of which I have advanced to the court, namely that an informal indication has no binding effect on an accused, and that may or may not change, and therefore it wouldn't achieve the public benefits that are intended to arrive from an early plea. The court will note that Haley referred to the formal indication of an indication.
How do you interpret the word formal?
A process operated by the state, whether that's through the court system or a legislative process, may not matter very much, but not left to the parties, if you like, to operate on an ad hoc basis.
Sure.
A system whereby, for example, that if it be by way of a letter, as in Scotland, is sent, that it would bind the defendant, save for some exceptional basis upon which he could vacate that.
Well, I don't think the letter in Scotland binds the defendant.
No, they can.
It is simply an indication.
Yeah.
And the court will have to take a view as to what benefit has been obtained from that indication. I should indicate to you that you are now exceeding your initial time. You're fully entitled to use up some of your reply time in order to complete your submissions, but you are now in that position.
Yes. Well, I was coming in any event to the second issue, and the court has our written arguments in relation to those matters. It's difficult to, in terms of advancing those arguments, it's difficult to improve upon the reasons that have been given by the court in Cayley and in Gemo as to why the strength of the case should not be a factor. And we respectfully adopt what the court said in relation to that. And we respectfully ask the court to consider the tension between the respective principles that are in operation in this court. These were touched upon in Cayley and in Gemmell, that if a suspect makes admissions in interview, that strengthens the case against him, and if he doesn't make admissions, he's prejudiced. So, and it would be very difficult, we say, in a lot of cases to know. It's not simply a case that if, for example, a person makes admissions in interview, it may lead to a line of inquiry by the police. They may go and interview people. They may get CCTV from locations. It would be very difficult after that is done to satisfy a court that it was the product of what was said in the interview. police may say, well, we would have done that anyway. But there's a clear tension between the Pollock principle and the MacDonald principle insofar as if admissions improve the case against you. So it's a lose-lose situation for the suspect, and that's a matter that was clearly articulated by Mr. Justice Colton in granting leave in this case. That he indicated at, I think it's paragraph 40 of his leave judgment, that where defendants come before the court and plead guilty on arraignment, they're often met with, well, the case was overwhelming against you, or alternatively, you didn't make admissions in interview. And he encourages the benefits to flow from the plea at that stage.
In light of the fact that this is a matter of sentencing policy, do you accept that this court should only intervene if it finds that the policy is perverse? That that's the legal test for intervening?
Our submission in respect of the first issue is the statutory interpretation.
I understand that, but on the second issue, that the test is whether or not the policy is perverse, or is there some other test?
We say it's wrong in principle and it's contrary to the policy of the discount. That is to the purpose of Article 33 is to encourage pleas for the associated benefits that
so
flow
it is
from that.
It is perverse. Is that
yes.
what you say?
And we say that to withhold that on the basis that the strength of the case defeats the policy defeats the statutory objective.
Yes, you say the statutory purposes are set out, I think, in 64 sub 2 of your case, and 113. That's reducing the impact of crime on the victims, saving the victims and witnesses from testifying, and the saving of public time and money. And you say that the question of remorse, or the question of being caught red-handed has nothing to do with that.
Yes.
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 So, but you would recognise, would you not, that in terms of mitigation, the headline figure before you apply the discount, those matters could be taken into account?
There will always be cases where it's clear. For example, if an accused walks into a police station and confesses to a crime before the police are even aware of it, it's clearly compelling mitigation on his part. The difficulty that arises is that in most cases it's very difficult for a court to know whether the plea is due to remorse, regret, or whether it's simply on the part of the accused to achieve the discount. And it will be virtually impossible in our submission for a court to accurately analyse those matters. And it requires really, in our submission, a broad policy decision that the strength of the case should not in ordinarily affect the discount to be given.
And you say in any view it is as a matter of law, you would say, outside the Article 33 exercise.
Yes. Yes.
Thank you.
So, unless, my Lords, I can assist the court in any other aspect, those are our submissions.
Mr. Rookies, your learned junior wishes to say something to you.
Sorry. No, thank you. I'll come back to this. It's the point raised by Sir Declan in relation to the interpretation, and I would just welcome an opportunity of looking at the statutory provision before commenting on it.
Yes, it is simply the definition of proceedings for the purposes of the provision concerning the intimidation of witnesses or persons who may be assisting in an investigation. But thank you very much. You can come back to that.
Yes,
And if we can get the Crown's submissions on Section 47 in the course of the Crown's
Lord, yes.
speech. So Article 47. Yes, Mr. McGee.
Well, my Lord, may I begin by saying, obviously, I'm conscious that an awful lot has already been committed to writing, and whilst I've suggested an estimate of the time that I require to respond, I'm hopeful that that's pessimistic, but will, of course, be guided by your Lordships as to the amount of detail that is required from me in response, bearing in mind the written submissions which I pray in aid of anything which I have to say orally. But can I begin by addressing both issues in an overarching manner in the following way, and say this, that in terms of the first issue, what we say responding is that as a matter of construction, the word proceedings in the context of the 1996 order includes consideration of matters anterior to arraignment, including events prior to the commencement of a prosecution in the Magistrates' Court. And I'm conscious that's been a subject of much of the debate already. And we refer, if needs be in due course, to the authority of Ambrose and Harris and other practical implications of that. But secondly, in order to satisfy the core objectives underlying the principle of credit for plea, which dictate the legislative intent, whilst taking into account the existing framework for criminal prosecutions, the Court, we say, must uphold the Court of Appeal in Northern Ireland's decision that proceedings includes such consideration. And thirdly, that Article 33(1) of the 1996 order is not prescriptive or exhaustive in terms of matters to be taken into account when determining sentence, and accordingly, the definition of proceedings cannot be determinative of whether such matters can be taken into consideration. What I should say, however, at this stage, and perhaps a matter which hasn't been certainly reinforced to date this morning, is the flexibility which the case of MacDonald and Maternahan encourages. In due course, with your Lordship's leave, perhaps I'll turn to that in terms, but we say that's critical, because what the order itself, Article 33(1), doesn't do, and what Maternahan or MacDonald and Maternahan doesn't do, is be prescriptive. What they do is provide helpful guidance and nothing which is mandatory, other than the fact of consideration itself. In terms,
the whole question of the percentage to be applied is a matter of judicial practice.
Indeed.
Yes.
And that, in our respectful submission, is something which this Court should be slow to interfere with, if at all. Lest it not need to be trammelled in any great detail, could I give the overarching submission in respect of issue 2 at this stage? We say that there's no basis for suggesting that a distinction cannot be drawn between a defendant who pleads guilty in the face of overwhelming evidence and one who pleads guilty when there are triable issues. One's looking at exactly the same point. One's in favour of the accused, one is against him. Even the appellant appears to accept that. In such circumstances, we say that one cannot find, nor would there be authority to suggest, that such a practice is perverse, and therefore this Court should not intervene. It's a matter for the Court to determine how that distinction should be drawn, and there is nothing unlawful in permitting that consideration to be taken into account in a fair, careful and proper manner when determining credit. And in our respectful submission, the Court of Appeal in Northern Ireland was correct to urge caution, as other courts have been, when looking at that aspect, but there is nothing wrong in principle in applying it to the sentencing process.
Some cases, Mr. McGee, are apparently very strong prosecution cases. Some are fairly strong. Some are good enough prosecution cases. All of them would be judged viable. But there's no gradation to the plea in relation to any of those cases. I mean, the fact that there's a plea to a strong case isn't different from a plea to there being a moderately strong case. Why should there be gradation having regard to the statutory principles in the red-handed scenario, but not in the other cases?
Well, my lord, what we say is that the way in which the process is set up allows the sentencing judge who has the best feel for it to apply whatever gradation is required.
But there isn't any gradation apart from this category about which one should be cautious. If in the other cases where the strength of the case will vary, it's not going to affect, as I understand it, the nature of the discount.
Well, my lord, not the nature of the discount.
Right.
But
why should the, in this particular instance, the nature of the discount be affected, having regard to the interests of that are sought to be protected, victims and witnesses, court time, and the interests of vindication of victims? What's the difference?
Well, perhaps, as I believe as Lord Burrows pointed out earlier on, perhaps it's simply a case of semantics to when the process is taken into account, and therefore it may not make much of a material difference. But very often in pleas and mitigation in Northern Ireland, we hear it being advanced as a forceful aspect of mitigation that there were triable issues in the case.
Does it make a difference?
And in those circumstances, mitigation is often afforded. And whether that's right or not is perhaps a matter of separate debate, and certainly from the prosecution perspective, sometimes it's hard to assess that because the same issues apply. But what we say is that if that sort of submission is being made in front of a Crown Court judge, a judge should be careful in that analysis, because of course whether something is a strong case or whether it isn't, as the courts have repeatedly said, is a matter of particular consideration. But we say it's right, my lord, to say that this is a particular way in which it's been dealt with in Northern Ireland. Indeed, in England and Wales, and previously as well, it's been looked at as a means of assessing credit. A similar issue, of course, arises with the issue of remorse, which is no longer a consideration in England and Wales, but remains a consideration in Northern Ireland. And so, the point which we make in response is there's nothing unlawful in that. It's a matter of sentencing practice, and that's a matter for the domestic court to determine how it applies what we say are clearly relevant considerations and are certainly not perverse. With your lordship's leave, if I could move to issue 1 and look at that in a little detail. And it's difficult to embark upon a reply to this appeal without stating what we say is the blindingly obvious. And we mean that with the greatest respect to the appellant and the arguments which have been advanced on his behalf. But the starting point is Northern Ireland is a separate jurisdiction to the rest of the United Kingdom. It has a separate sentencing regime. As this court's very aware, sentencing council guidelines do not apply unless expressly approved by the Court of Appeal. And the rationale is simple. We have a small jurisdiction. We have a full-time judiciary. Information sharing allows for greater consistency than might be achieved in a large jurisdiction with a large number of part-time judges or recorders. And that's a lesson that I learned very early on from my return from practising in England and Wales to Northern Ireland before Sir Declan Morgan himself in a case called McGaughey and Smith. But that's the principle behind it. It's dependent upon locally encountered conditions, which is the principle expounded in the case of Devine, which can be found at tab 35 of the bundle. Locally encountered conditions dictate how sentencing processes are applied, and was as identified by Mr Lord Justice Stevens as he was in the Court of Appeal judgment in this matter, that were the guidelines to be applied in Northern Ireland, that being the Sentencing Council guidelines which are relevant to this appeal, it would result in significant change, largely unattractive to the accused. The tariffs for murder, for example, which are significantly higher in England and Wales to Northern Ireland. What we trust has been demonstrated in our argument on paper is that it's simply unfeasible to, and if the court will forgive the pejorative, to cherry pick not even one scheme, but one element of a scheme from a different jurisdiction and apply it so as to benefit one party. Perhaps an inelegant analogy is this, that You might look at a beautiful tree and wish to remove its more attractive fruit to enjoy it in your own home. But without the branches, the trunk, the sap, the roots, the attractive blossom or fruit will wither and die. And in our respectful submission here, what is being sought is the removal of a piece of fruit, when to make the fruit last, you'd need to remove the orchard. Because it's a part of a package. And what the appellant seeks is one piece of fruit which suits to be applied, utterly neglecting what's required to sustain it. In our respectful submission, the case of Cayley requires careful consideration, as in our respectful submission, whilst relied upon heavily by the appellant, it in fact doesn't assist. And we say that's because it's essential to revert to the core principles behind the policy. Now, my learned friends relied upon the Royal Commission in 1993 as the cornerstone of why this principle is in place. We don't demur from that. But we'd respectfully remind the court that it was the same commission, for example, that recommended the wholesale abolition of committal proceedings as part of those recommendations. Committal proceedings, which I venture to suggest there are few practising barristers or solicitors in England and Wales that have ever taken part in what was known as an old-style committal. But I have. My learned friend has, because it's still going on to this day. So it's not comparing apples with apples. It's not even comparing fruit with fruit. And unless one focuses on that in our respectful submission, the whole point of the reduction of sentence for credit for a guilty plea is utterly lost. And that, in our respectful submission, is plain from the case in Cayley. The Cayley can be found, my lords, at tab 9 of the core bundle. And could I perhaps invite the court for a short time to look at it in a little detail? And begin at paragraphs 9 to 22.
We don't have it in paper form, so could you give us the
Yes, of course. Forgive me, my lord.
Number, please.
It's the page 844 is where I intend to begin, my lord.
Thank you.
Thank you. Do your lordships have sight of that now?
Paragraph?
Paragraph 10, please, my lord. At paragraph 10, the purpose being pursued by the Court of Appeal is plain. And that's twofold. First of all, to give some general assistance. Secondly, toward the end of the paragraph, to achieve greater consistency in that jurisdiction. That's what the purpose of the guidance was. As I've already indicated, no point gets better by repetition. Northern Ireland has a very distinct judicial body, which the Court of Appeal in Northern Ireland has repeatedly stated benefits from its small size and full-time professional capacity. Then the overarching aim of what the Court of Appeal in Cayley were trying to achieve, and if my lords would turn please to paragraph 17, and I hope not to hop around too much, but we say the aim is relevant to the entire consideration of this appeal. And if the courts would indulge me, I'll read from paragraph 17. The various procedures all serve a similar end. They aim to advance the point at which everyone can know whether a trial is going to take place or not. The sooner this is done, the greater advantage for the victims and witnesses. The sooner it is done, the greater the public saving in preparation of trial-ready evidence by the Crown and in successive Crown Court hearings. The point at which there is in practice great savings in the assembly and service of evidence and in the investigation and making of disclosure is if and when an indication of a guilty plea is given in either the magistrate's court or immediately on arrival in the Crown Court. And of course, that's against the context of in England and Wales no committal proceedings, or at that point in time only paper committals, which were rarely used, but the sending procedure under the Crime and Disorder Act, which was in existence for indictable only offences. So, my Lords, that's the overarching aim. So by the time the case gets to what was then known as the plain case management hearing, which you'll see reference to at paragraph 18, the first reasonable opportunity was gone. Paragraph 18, my Lords. All this leads us to the clear conclusion that, absent particular considerations individual to the case, the first reasonable opportunity for the defendant to indicate, not necessarily enter his plea of guilty, if that is in mind, is underscored, not the PCMH. Not the PCMH. The PCMH in England and Wales, as it was known then, now known as the PTPH, is the equivalent of arraignment. It's the first time when the charges are formally put to the defendant for him to enter pleas. And what the appellant argues in this case is that that is the first reasonable opportunity in Northern Ireland. Reliant upon Cayley, which says it clearly is not. So in our respectful submission, Cayley is not a case which on the basic and bare principles assists this appeal. And the reason being that the opportunities and the savings identified at paragraph 17 are lost if one waits until the first formal opportunity for arraignment. Can I then please invite the court to look at paragraph 13, which addresses the method in England and Wales for achieving this. Paragraph 13 does look at the concept of treating admissions in interview as additional mitigation prior to considering the reduction for guilty plea. Well, what that, in our respect submission, does makes it plain that it's not unlawful to utilise the defendant's position in interview as some means of indicator and some means which has to be reflected in the overall sentence. And then at paragraph 20, it notes that at the Magistrates' Court, the defendant, through their counsel or solicitor, notifies the Crown that he would admit a lesser charge or invites discussion as to the appropriate charge at any rate where the position taken up is a reasonable one. So what the court is underscoring is that there is a responsibility on legal representatives to identify to the Crown a reasonable position which can therefore be taken into account by the sentencing judge at the point of passing sentence. Paragraph 21 deals with one of the points raised earlier this morning in terms of the role of advocates and counsel. It requires trial counsel potentially to be instructed earlier or for Magistrates' Court advocates to be prepared to advise on the issue of credit. Again, all to achieve the common aim of identifying as early as possible whether there's going to be a plea. And my learned friend, in the course of his response to some questions this morning, indicated that, first of all, it would have to be some sort of formal process. Yet, Article 33 doesn't require that. And that there would have to be something binding for it to have any effect. Well, my Lords, what we say in response to that is this. Under the Criminal Justice Evidence Northern Ireland Order 2004, Article 22.6, and the equivalent provision under the Criminal Justice Act 2003, the hearsay provisions, as they have done since 1880, mean that admissions by an agent can be held against the lay client. In the case of Downer in 1880, a letter written by a solicitor is admissible if shown it was written on his instructions. And there's lots of recent authorities in relation to PCMH forms in England and Wales where admissions in one regard on a PCMH form have been interpreted as being an admission of identity, for example, in a case. So it doesn't require something formal if the court is minded to take the view that even were the court to take the view that proceedings don't start until the point of charge. There's ample opportunity for the accused to indicate his intentions. And my Lord, we say that's of particular relevance in this case, because in this case, the court has already identified the delay that there was between the first appearance in the Magistrates' Court and the arraignment hearing. It was somewhere in the region of 14 months. Whereas, and in a moment, if your Lordship will permit me, I'll come to compare that to the case of Cayley and Placu as to how swiftly matters happened there, but how quickly credit drained away in spite of that. And that's because of streamlining in the English and Welsh system. And those streamlining provisions have been ongoing since the Royal Commission's report in 1993, but the provisions in Northern Ireland haven't kept pace with them. And that may be a point of shame or disappointment that that is the case, but it is the system, and it's incumbent upon the legal profession and the judiciary to attempt to deal with those legislative provisions in a manner which still achieves the same objectives. So, in England and Wales, you have the situation where there is always a formal opportunity to indicate guilt, but that is not what is required under Article 33 of the 1996 order. There's no suggestion. Indeed, in our respectful submission, the provision almost encourages informality. It encourages thought by the judge. It encourages positive involvement by the defendant. And can I perhaps say this, my Lord? Perhaps it comes back to a conceptual problem on the part of those who defend in cases. That because there is a right to remain silent, because there is a right to challenge evidence at committal, to call the 90-year-old victim of a burglary to give evidence at committal, because there are those rights, that therefore it shouldn't be held against them if they exercise those rights. But the exercise of rights very often have consequences. And the consequences are spelt out by Lord Justice Kerr, Chief Justice Kerr as he was then, in Maternihan and MacDonald, in the plainest of terms, which is why in our respectful submission it's concerning, if it is the position, that the perception of practitioners in Northern Ireland is that the first opportunity is at arraignment. And we say, how could that be the case? Because Lord Chief Justice Kerr, as he then was, could not have been more plain what the implications of remaining silent were. And so, if that is not an unlawful practice, in our respectful submission, it is not appropriate for the court to intervene, particularly on the appeal which is premised in the way it is in this case. Returning briefly, and I'll come to the practical implications of Cayley as against this case, which we say is demonstrative of why there are distinctions and why one can't just lift the fruit from the orchard. There is a distinction to be drawn, as this court's already recognised this morning, between the first reasonable opportunity to indicate guilt and the opportunity for lawyers to assess the strength of a case. Now, again, it may be a perceptional problem, because it appears to be the case that, well, if that's something you're entitled to do, it shouldn't be held against you. But the Court of Appeal at paragraph 14 in Cayley couldn't, again, have been more clear about it. There is that distinction, and it has an impact. It's one thing knowing whether or not you're guilty, in the sense you committed the offence. The burglar who went into the house and came out with the handbag and is stopped by the police officer at the door, as against assessing your likelihood of acquittal. Well, they mightn't get the forensics on you. She's 91 years of age. She'll never remember you. She'll never pick you out in a lineup. And the police officer wasn't there at the time, was he? There's a distinction to be drawn there. And simply because you're entitled to go down that line doesn't mean you're entitled to full credit. And that's what, time and time again, the Court of Appeal, not only in this jurisdiction, but equally in Scotland, in Gamble, drew attention to. So you can't just say because you're entitled to be advised by your lawyers that means that you're entitled to full credit, because that would undermine the fundamental principle, because there might be a technicality you could get off. Again, there are countless examples of where tactical approaches, tactical pleas, have been deprecated as a means of preserving credit. It's something you're entitled to look at. Wait to see if the witness turns up, for example. It's something you're entitled to do, but it undermines, not supports, the fundamental objectives of the principle of credit. It puts witnesses through fear. It puts the pressure on witnesses. It means full files have to be built. It costs a fortune. And it certainly isn't evidence of remorse. And so in our respectful submission, when one goes through the building blocks of why the Court of Appeal in Keighley got to where it did, and what we respectfully submit the appellants are saying here is, we'll take the headline, but we'll ignore how the Court of Appeal got there in the first instance, because none of those building blocks are ones which, in our respectful submission, the appellant seems to be willing to utilise to get to their own conclusion, because they're not there in Northern Ireland.
Whether they're there in Northern Ireland or not, how do you answer the question as to what constitutes an indication of an intention to plead guilty in a police interview? What does that actually mean in a context where one hasn't at that stage got a charge?
Well, my Lord, first of all, as my Lord Sir Declan Maughan pointed out earlier on, PACE, which I think is the first authority in the tab, in the core bundle, first of all makes it plain that before anyone's interviewed, they have to be given they have to know the nature of the offence which is being investigated. And in the vast majority of the cases, at least some, if not all, of the headline offences under investigation are maintained to the point of charge. Charges being changed and fiddled around with when counsel get hold of it is not unusual. But what's important is you know what you're being questioned about. If you've been driving down a road and you knock over a pedestrian, in our respectful submission, you're under no illusions by the time you get to the police station what you're being questioned about and what the likely offences are which are under consideration.
So am I right in thinking that you would read admissions at police interview as an indication of intention to plead guilty?
We would read it as exactly how Lord Chief Justice Kerr said you should, which is it is an indicator of your intention.
So the answer is yes.
Not that it is. It's not necessarily the intention, but it's something to be factored into account when determining what when you had indicated.
My question to you is, if there's an admission in interview, is that an indication of an intention to plead guilty?
In our respect of submission, yes, it can be.
That certainly is the way it's been treated by the courts in Northern Ireland.
Yes, consistently. And in our respect of submission, in the vast majority of cases, there's no difficulty with that, because the questions you're being asked in police stations for the vast majority of offences are not complex. And Maternihan is so flexible, and forgive me for returning to the same point again. MacDonald and Maternihan, forgive me for also calling it Maternihan, it's very often referred to as that rather than MacDonald by Crown Court practitioners. But MacDonald and Maternihan is so flexible that it takes into account all the difficulties which the appellant in this case argues are so difficult, are perplexing. The unrepresented party, well, there's no requirement on a Crown Court judge to withhold credit. He must look at all the circumstances. In Article 33(2) specified you must look at the circumstances. So the unrepresented defendant, the defendant where there are mental health issues, that all must be taken into account. If there's evidence of that, it would be perverse for the court not to take it into account. But that's precisely what Lord Justice Stevens, in the Court of Appeal decision in this case, and indeed Lord Chief Justice Kerr said in Maternity and MacDonald. Where something is complicated, where it requires specific advice, again, all matters which can be explained at a plea and sentencing hearing in the course of mitigation, and the court can take it into account. MacDonald-McTernan isn't saying, and indeed Lord Justice Stevens, in our respect submission, was entirely right to correct His Honour Judge Miller, the sentencing judge in this case, when he said that credit will only be given to those who admit matters at the first opportunity, which is during the course of interview, because that's not what Maternity says. It says your attitude in interview will be relevant to that assessment. So the Court of Appeal were right in our respectful submission to make that distinction, and it's an important one, which is there to protect a defendant who doesn't have the benefit of a fully qualified solicitor present, as in Northern Ireland you're entitled to, or who has a mental health issue, or who has a complex case and doesn't quite understand it. All those matters are well within the realms of good advocacy at the point of plea and mitigation. And in our respectful submission, that is why one is perfectly entitled to look at the attitude in interview and ask it, the sentencing judge is entitled to ask himself or herself the question, does that help me in terms of identifying an indication to plead guilty?
I don't think anybody's taking issue with that to some extent, Mr. McGee. The issue is what's the meaning of proceedings in Article 33, and that may affect how you take it into account.
Yes, well, can I turn, and I'll turn to that immediately afterwards. But I did say to them, earlier on that I would try and identify why we say this case is a stark example of why trying to adopt the English system to Northern Ireland doesn't work when one looks at the time frames. This is a case, as I've indicated, where, unlike in Cayley, where I believe it was somewhere in the region of 2 months or 2 to 3 months between the offence and the conviction. In Placu, 28 days, both cases down to 25%, and in this case, 14 months, and in the intervening period, 14 appearances in the Magistrates' Court where the prosecution were preparing a full file. 14 appearances. And we take on board the appellant's point that, well, there's no requirement on us to say anything. But there's plenty of opportunity. Because it goes without saying that the Magistrates' Court are concerned by the delay. And perhaps this will lead me into the point which Sir Declan Morgan's asked me to address the Court upon, as to why delay is an important issue in terms of the definition of proceedings. But the courts
in the statute.
Well, yes, in the statute, but also in terms of.
You've got to look at this statute in the context in which the word is used as a starting point, surely.
My Lord, yes. There isn't, of course, and I've had an opportunity, I'm grateful to the court, I've had the advantage that Mr O'Rourke hasn't had of having looked at the provision which Sir Declan's identified. And
that is, of course, specific only to that article.
It is, yes. Yeah. And the wording's slightly different.
It also reflects what the law would have been at the time of the passing of the statute in the common law.
I entirely accept that. Of course, it is a provision which takes the time to provide a definition.
Yeah.
Whereas Article 33 does not take the time. And it's not like in most statutes where one comes to a definition section at the end and proceedings is defined for all purposes.
But could I suggest that the objective that you're seeking to achieve can be achieved in two ways? One is by a redefinition of proceedings, for which there are some contraindications within the statute. But the second is by an interpretation of stage in the proceedings to include pre-proceedings.
Yes.
And that would achieve exactly the same outcome, in effect.
My Lord, yes, I wouldn't demur from that. One of the reasons why we submit as we do that proceedings includes anterior proceedings is, and it's set out, we would say, well, in the likes of Ambrose and Harris. And the case is so well trammelled, I don't intend to take this court through the judgment.
But does that mean that the meaning of proceedings changed once the convention came into being, or Ambrose and Harris was delivered?
Well, even if it did, my lord,
I'm just asking the question.
I'll use the difficult ones from this particular corner. My lord, I'd venture to suggest that yes, the definition has changed. But for the purposes of these proceedings, it matters not. And what this court is concerned with is determining today whether or not proceedings includes anterior proceedings to the court process, including the interview. And what we'd say is this, and this is what brings me back to the issue of delay. In bail applications, which we've heard reference to this morning, in sentencing hearings, one will often hear reference in submission by defence counsel to the reasonable time requirement, which is prayed in aid of getting a shorter sentence, a discount of anything up to 10%. And the starting point, which they rely on for the purposes of getting that discount, is when he or she is first interviewed. So if a defendant is interviewed in 2006 and proceedings don't occur until 2018 or 2019, the court will be invited to look at when they were interviewed to see whether or not there was a breach of the reasonable time requirement. And so in our respect submission, sauce for the goose is sauce for the gander. You can't turn around and say, well, for that purpose it suits us to say proceedings commences in the police station when he was first made aware of this. Why didn't they act quicker? Why didn't they charge us quicker? Why did it take the Public Prosecution Service 3 years to review this case and get it to the Magistrates' Court? So you can't have it both ways. And in our respect submission, that is why it's perfectly proper to deploy what was said in Ambrose and Harris in this context as to the point in time when the position of the defendant actually changed. And there's nothing perverse in that. Indeed, in our respect submission, it would be perverse not to. Because the right to a fair trial pursuant to Article 6 isn't a right to a defendant winning all the spoils, things going fairly for him. It's a fair trial for everyone. And so one can't just pick and choose the authorities on the issue of when proceedings start, because in one circumstance it assists the defence and in the other it doesn't appear to. So we say that means it's a perfectly proper interpretation. One could look at other examples. There's a reasonable time requirement. There's the right to a solicitor, the right to silence, all derived from when proceedings start under the definition of Article 6 of the European Convention of Human Rights. Now, my learned friends have identified an authority called Carr and Atkins in the course of their skeleton argument. And could I make the following points in relation to that if it would assist? In that case, it was a decision where the issue of jurisdiction in judicial review was being considered. And, my lords, if it helps, it's found at tab 51 of the other authorities. But the court's focus was on jurisdiction in judicial review. But in the judgment, there's no exploration of what in fact was going on in the criminal investigation. It was in relation to production orders being sought under PACE. And the appellant seeks to draw an analogy with that, saying, well, look, if PACE was deemed in that case, and the quotation which is lifted from it was saying that there was no criminal investigation. Well, one has to look to see what the state of the investigation was, whether or not the defendant's position was actually affected. We don't know. All we know is it was a police investigation going on, and they were looking for material from a third party, and hence production orders were sought. But unless you know whether or not he'd been interviewed, whether he'd been charged, etc., then you can't actually decide whether or not they were right in saying that a criminal investigation hadn't commenced or not. The bottom line, of course, is that the court's focus was on whether or not it was a criminal cause or matter for the purpose of a judicial review and deciding jurisdiction. And in our respect of submission, whilst imaginative, in our respect of submission, the case actually doesn't take the point any further. In our respect of submission, the case of Harris and the general principles which this court is more than familiar with as to when proceedings start are of greater assistance when looking at the context of this appeal.
So, Mr. McGee, when do you say the proceedings commenced in this case?
We say proceedings commenced at the point in time whenever he was made aware of what the offences he was being investigated in were made known to him. And in this case, that was at the point of interview. Well, attempted interview.
He was never interviewed.
Attempted interview. And can I...
Well, was he told in the attempt what the offences were?
He had to be for his instructing solicitor to be there.
The solicitor would have been told, but was he told?
Well, what we can say, and the papers are within the appellant's additional documents, and this was an issue which was looked at in some detail previously, I think, for the Court of Appeal proceedings, that significant efforts were made to identify to him what was happening. Of course, he had been arrested in the court just after a car chase, which had been driven from one of the sites of the burglaries, and in the back of the car were the fruits of the spoils. So, in our respect, and what I should also say is that he'd been deemed fit for interview by an FMO, so there's any suggestion that perhaps there's some doubt here that perhaps Mr. Maughan was hard done by, in our respect submission, does not stack up. He had an appropriate adult. He had been seen by a doctor and deemed fit for interview, and therefore one would anticipate fit to understand what he was about to be interviewed about, as the police would have been under a duty to advise a solicitor. And of course, again, we can turn to the PACE guidelines if needs be, but the solicitor would be provided with advance information to be in a position to attempt to take instructions from his client. And so, in our respect of submission, this, of all examples, is a bad one of when a defendant should not have credit withheld as a consequence of a failure to answer questions in interview. My Lord, there is much that I could say which is already set out in relation to issue 1 within our written submissions. But I'm conscious of how the argument this morning has been directed, and in particular the emphasis on when proceedings start. I hope that in relation to issue 1 I have addressed the court in relation to what we say the definition of proceedings is and should be in terms of the interpretation of Article 33(1), and how, practically speaking, not only from the point of interview but during the course of magistrates and Crown Court proceedings, it can be implemented. And subject to the court, I simply pray and aid my written submissions in relation to issue 1, unless there's anything in particular this court wishes me to address them upon. I hope that's perhaps a better use of time than repeating what is already in writing.
Can I pick up one point?
Yes,
I mean, even if you were to be wrong that proceedings in Article 33 was at a stage, included a stage before the charge or the summons, is there anything in Article 33 that militates against the sentencing policy of further taking into account assistance provided at an earlier stage, which could be characterised as an intention to plead?
My Lord, we say no, that Article 33 is drafted in such a way as that it is broad enough to be inclusive rather than militating against any relevant consideration. The reason why we say that, the provision itself is behind tab 3, which is page 700 of the digital bundle. In determining what sentence to pass on an offender who has pleaded guilty to an offence, the court shall take into account, and that's therefore a consideration, the stage in the proceedings for the offence which the offender indicated his intention to plead guilty and the circumstances in which this indication was given. Now, my Lord, we say that either the court can interpret the issue of proceedings to be within that consideration which is mandatory, even if the court's against me on that. The first sentence, in determining what sentence to pass on an offender who has pleaded guilty to an offence a court shall take into account, does not prevent the court looking at other considerations which, of course, a court does in the course of passing sentence. So it's not prescriptive. And in our respectful submission, there's nothing in the wording which militates against its consideration. In fact, we say the contrary.
Yes, because the practice of having 33% in certain circumstances, 25% in other circumstances, maybe 10% in others.
Yes.
None of this is laid down as a matter of law.
No.
In this article, it's entirely for the judges to decide how to apply this scheme.
Well, Lord, yes.
Yes. So, I mean, even if this court were to be against you in the interpretation of proceedings, does that in any sense render unlawful that which the judges have been doing in Northern Ireland?
My Lord, we say no, and it's perhaps, as ever, always better articulated when you have time to sit down and write it rather than when you're on your feet. But the way we put it in paragraph 1 of our case statement at page 115
yes.
is that further and alternatively, the provision is neither exhaustive nor prescriptive and is therefore within the discretion of the sentencer to take account of the offender's attitude in respect of guilt during the course of police interview. So we say it matters not what the definition of proceedings is for this purpose. We say that the Court of Appeal was right to interpret proceedings to include anterior proceedings, including the police interview. But even if the court is against me on that, there is nothing within Article 33 which would prevent a sentencer in Northern Ireland from taking it into account in accordance with well-known principles. And in our respectful submission, Lord Chief Justice Carr couldn't have made it more clear as to what the application of the principle should be.
Thank you.
My Lord, can I then turn to issue 2 briefly? My Lord,
what do you say the test is for issue 2?
We say that unless this court is, because it's a matter of sentencing practice, unless this court is of the view that it's perverse, that this court should not intervene. And in our respectful submission, one only has to look at Cayley and indeed in Gemmell, that whilst there is in Gemmell the Scottish Court of Appeal and its subsequent decisions have moved away from that practice. There's no suggestion it's unlawful or perverse. In the interests of achieving consistency and taking out of the equation the potential risk there is of assessing a case, then that's what the Scottish courts have moved away from. But can I draw to the court's attention 2 distinctions with Scotland, one of which we had the presence of mind to include in our written argument, and one of which only occurred in recent days. First of all, and it's perhaps of more importance to the first issue than the second, there's the right to silence, absolute right to silence in Scotland, which is unqualified. And therefore we say one can understand why the Scottish courts have found that it would be perverse to hold it against someone for the purposes of sentencing if they haven't made admissions in the course of interview. The second distinction, which we haven't picked up on, but occurred to me upon reading the case of Gemmell again, is the requirement for corroboration in all criminal cases in Scotland. And that is perhaps more pertinent to the second issue. Because, again, we can see why in Scotland, where that principle is in existence, unlike anywhere else in the United Kingdom, for it to be incumbent upon an accused to provide corroboration, an essential proof for the prosecution, and if he doesn't, therefore be held against him for the purposes of sentencing. England and Wales doesn't have that. Northern Ireland doesn't have that. And perhaps it provides some explanation, I'm not saying completely, but as to why the Scottish courts have taken a different course. In our respectful submission, and I hope I can put the point shortly, the way in which the Court of Appeal in Northern Ireland in the present case reinforced the care which sentencers are encouraged to take and have been encouraged to take since Cayley when applying this particular principle is the correct approach. It's not something which a court should do lightly, but in the present circumstances of this case, one only has to look at the facts of the case and the amount of evidence which there was ultimately in relation to this particular appellant. We say that the sentencing judge could readily come to the conclusion that the defendant had been caught red-handed But it is something which we say needs to be handled with care, and the guidance which the Court of Appeal has given is the correct guidance. It leaves a small margin of discretion, perhaps, smaller than might have been obvious from Pollock. But in our respectful submission, it's a discretion which is perfectly right to remain, and one which, given the guidance of Lord Justice Stevens in the case of Maughan, we say the sentencers in Northern Ireland will feel confident that they are able to apply and apply properly. My Lords, those are my submissions, unless there's anything particular which your Lordship would require me to respond to.
Thank you very much.
Thank you, Lord.
The court will adjourn now and resume to hear your reply at 2 o'clock.